It is my honor to introduce our next speaker, Ambassador Allan Rock. Ambassador Allan Rock is President Emeritus of the University of Ottawa and a former professor in its Faculty of Law, where he taught international humanitarian law and armed conflict in international law. He served as Canadian ambassador to the United Nations. He is a senior advisor of the World Refugee and Migration Council and a member of the Transatlantic Commission on Election Integrity. He practiced in civil, administrative, and commercial litigation, appearing as a counsel in a wide variety of cases before courts at all levels, including the Supreme Court of Canada. Allan Rock was elected to the Canadian Parliament in 1993 and re-elected in 1997 and 2000. He served for that decade as a senior minister in the government of Prime Minister. He was Minister of Justice and Attorney General of Canada, Minister of Health, and Minister of Industry and Infrastructure. As Canadian ambassador to the United Nations, he led the successful Canadian effort in New York to secure the unanimous adoption by UN member states of the responsibility to protect populations from genocide, ethnic cleansing, and other mass atrocities. Allan Rock served for 2 terms as the president of the University of Ottawa. Ambassador Rock, welcome back to the College of Charleston.
Thank you, Sid, for your kind introduction. And is this working? No? Yes? Okay, thank you. It's a pleasure to be back on this beautiful campus. I'm very grateful for the invitation. The presentations at this summit have been fabulous. And I deeply regret that I didn't know either John or Karen Mroz, but clearly they're remarkable people. And it's great to see their name and their legacy perpetuated in the activities of this great institute. I was up a little late last night, perhaps with some of you, watching the Canadian hockey team conducting our foreign policy on ice. And I hope the message was received loud and clear in the White House. I should perhaps first explain how I became convinced of the need for radical, urgent, and effective measures to confront the scourge of grand corruption. Grand corruption, which is defined by Transparency International as the abuse of high-level power to benefit the few at the expense of the many. I have for almost a decade been a member of the World Refugee and Migration Council, which is chaired by my friend and former cabinet colleague, Lloyd Axworthy, who, as Canada's foreign minister, led Canadian priority campaigns to advance such worthy goals as the creation of the International Criminal Court, who put the human security agenda before the Security Council during our term there, and who also led the effort to create the Landmines Treaty. Now, the Council's purpose is to develop and to advocate the adoption of ways to respond more humanely and more effectively to the worldwide challenge of refugees and asylum seekers. There are today 122 million people around the world who have been forcibly displaced. And that number rises every day. They are displaced by virtue of various factors: war, persecution, human rights violations, natural disasters. One of the root causes found in almost every case is the failure of government due to grand corruption. And so the Council examined the nature of grand corruption and what can be done about it. We looked at a variety of issues: how to detect, deter, and punish corruption, how to locate, confiscate, and return the proceeds of corruption, so the looted assets can be used for proper public purposes, how to strengthen existing anti-corruption measures and international institutions pursuant to principles of accountability and restorative justice, how to provide better technical assistance and capacity building, including forensic accounting and tracking and tracing of illicit proceeds, and how to go after the people who enable the kleptocrats. These are the lawyers, the accountants, the financial advisors who make it all possible to launder money and to hide the proceeds of corruption. It became very clear to us in our work that there is a major gap in the international structure of law. The laws that prohibit corruption exist. The challenge is to enforce them. And indeed, in states where the kleptocrats control the government sufficiently to steal money from the treasury, they almost always also control the police, the prosecutors, and the courts. So it's highly unlikely that Maduro in Venezuela is going to be prosecuted for the crimes he's so obviously committing by stealing from his own people. We became convinced that we need a new international institution devoted to the investigation and prosecution of those who are corrupt, to break the stranglehold that kleptocrats have on the law and its enforcement. This is not to usurp the jurisdiction of each state to enforce its own laws, but rather to have a court that operates on the principle of complementarity, a court that will only investigate and prosecute if the state in which the corruption occurred is unable or unwilling to do so. Today, I'd like to briefly sketch out the case for the establishment of this new institution and address some of the common questions that arise when we discuss it. First, let me touch upon the nature and extent of the problem that we seek to address. The scale of grand corruption, or the misuse of public office for private gain, is difficult to quantify, but by any standard, it is enormous. An organization called Global Financial Integrity, which is recognized as a leader in the research and advocacy of illicit financial flows, estimates that developing countries likely lose to corruption an amount 10 times greater than they receive in development assistance. Grand corruption exists in many forms, whether it's bribery, extortion, influence peddling, graft, embezzlement. Corruption undermines democracy and corrodes the rule of law. According to Transparency International, it also costs lives. They have found that corruption in the health sector results in the preventable deaths of 140,000 children every year. Corruption deepens poverty, increases inequality, undermines good business. It destabilizes governments. The stolen money was intended to accelerate development, to improve public health, to create infrastructure, finance education, recover from natural disasters, and slow or adapt to climate change. And speaking of global warming, the COP29 conference in Azerbaijan a few months ago resulted in an agreement by which the developed nations would contribute $300 billion each year to developing states starting in 2035 to fund climate adaptation. We can be forgiven for wondering how much of that money will actually be used for the purpose. Now, corruption does not flourish because we lack laws. The United Nations Convention Against Corruption, which is now some 25 years old, has 189 state signatories, 189 out of 193 countries in the world. And that convention obligates each state party to adopt domestic laws criminalizing the various forms of corruption. So there's no need for new laws, no need for new norms. What we need is enforcement. As I mentioned, the worst offenders also control the police and the judicial system. So enforcement does not exist. Now, in this effort of creating a new international institution with a coordinated focus on anti-corruption, we're not starting from scratch. There's already a high level of international cooperation and coordination. There's already an organization called the International Anti-Corruption Coordination Center. As the name implies, it involves cooperation and coordination among police forces and prosecutors in sharing information in investigations of those who are engaged in corruption. 8 major economies are committed to that center, including many associate countries. It has created the Financial Action Task Force, which leads an international effort to share information and coordinate efforts. We also have in the post-9/11 world an international web of rules, regulations, and agreements that are primarily aimed at stopping the financing of terrorism, but also provide a ready pathway for tracing illicit funds stolen by kleptocrats. So, despite all these advances, there still exists no international institution to hold kleptocrats to account when the countries they rule are unable or unwilling to do so. An international anti-corruption court would fill the enforcement gap. It would operate, as I mentioned, on the principle of complementarity. It would provide a politically neutral forum to fairly and effectively prosecute and punish kleptocrats and those who enable them. It would deter grand corruption by establishing a credible threat of prosecution, which does not now exist. It would recover, repatriate, and repurpose stolen assets for the benefit of victims. And it would make its specialized experts in investigating, prosecuting, and adjudicating grand corruption available to states seeking to strengthen their own anti-corruption capacity. Now, this is a very worthy goal, but we're very conscious of the fact that in today's fractious world, it will be difficult to achieve. We're under no illusions about that. And I'll speak in a few moments about why we're optimistic that this can be achieved. This effort's about 10 years old. It was started in 2014 by a federal court judge named Mark Wolf in Boston, who leads the NGO that is behind the organization of the effort. And we've been aware from the outset that the United States would likely not become a member of this court because of its traditional allergy to such organizations. We had hoped for many years that we could achieve at least a neutrality on the part of the United States, that if they weren't going to join, at least the government of the United States wouldn't actively oppose the creation of the court. That is now in doubt with the Trump administration in office. But some of us believe that that can't last forever. This effort will continue. And there's sufficient support around the world for it to happen. So I don't want to give the impression that this is a pie in the sky exercise. We're realists. We understand it won't be easy, and the current conditions in particular make it difficult. But we're profoundly convinced that it's well worth the effort. So let me deal with some of the questions that arise when those who hear about this proposal want to have more detail. I'm often asked, well, the kleptocrats won't join this court. So what's the point? Again, I refer to Maduro in Venezuela as a hemispheric example of grand corruption. He's not likely to join. My answer is that he need not. His absence will not defeat the jurisdiction of the court. Very few kleptocrats keep their money at home. They know better. They want to put it somewhere where it's safe and where the returns are more assured. They deposit their money in developed countries, including Canada. And so long as those countries are states parties to the International Anti-Corruption Court, the court will be able to exercise jurisdiction in prosecuting those who took the looted assets. Jurisdiction in the court will be over nationals of states parties and acts of others in the territory of states parties. So long as Canada is a member of the court, if the crook deposits the money in Toronto, the court will have jurisdiction to confiscate it, investigate its origin, and prosecute those who took it. What about the cost of such a venture? People refer to the International Criminal Court, which has now been functioning since the early 2000s. The International Criminal Court is estimated to cost about $200 million a year. And if you look at the rate of indictments or convictions, you'll find a ratio that's very low. And you wonder, how do you justify that level of expense given the low level of productivity in the criminal court? Well, I won't get into the argument of the importance of deterrence and having the court there and the effect it's had on the conduct of some of the international criminals we've seen operating over the years. But let me simply say that in designing the International Anti-Corruption Court, we're learning lessons from the ICC and how it is organized and how it is operated. One of the key participants on our team is Justice Richard Goldstone from South Africa, former constitutional court judge of that state, and who developed an international reputation as a result of his involvement in some of the special courts to prosecute war crimes. Justice Goldstone last year completed a thorough analysis of the first 20 years of the ICC and made recommendations about how it could have and should have been made more cost-effective. We have the benefit of Justice Goldstone's advice and those lessons as we're designing the IACC. There will be no marble palace in The Hague. There will be no EU headquarters. The IACC will have a more focused jurisdiction than the ICC, with procedures less complex and protracted. For example, it will not have a pretrial chamber. The number of judges will be limited to match the caseload. There will not be a large permanent roster of judges paid to sit and wait for business to arrive. The IACC will use courthouses in member states' jurisdictions. It will use member states' financial analysts and prosecutors when possible. It will draw on member states' financial tracing and tracking capacity, and its financing will be assisted through the levying of fines against those found guilty of corruption. And let's keep this in perspective. If the ICC costs $200 million a year, that's roughly the cost of 2 F-35 fighter jets. Let's also remember that if you take into account the total amount stolen every year around the world, if an IACC could reduce that amount even by 10 or 20%, it would well justify the effort and the expense of its operation. What about the difficulty of proof? Won't the crooks hide the books, make it difficult for us to find them? Well, member states already have tools that can be used. There are increasingly registers of beneficial ownership, unexplained wealth orders, sophisticated tracing and tracking. All of those exist and can be expanded. Investigators and prosecutors can seek the cooperation of domestic courts in granting subpoenas and search warrants. And of course, there are courageous and resourceful journalists, such as those who produced the Panama Papers some years ago, uncovering corruption that led to the resignation or impeachment of heads of government in various countries around the world. Through mutual legal assistance treaties, we can strengthen the capacity of states to investigate and uncover evidence. And let me touch upon one other important dimension of this court. The principal purpose of an IACC would be to prosecute those who allegedly commit corruption offenses. So we're looking at accountability and deterrence. On conviction, the court can order the looted funds or corruptly acquired assets to be forfeited and returned. But even the busiest, most efficient IACC will touch only a small portion of the massive amounts taken corruptly each year, because the number of prosecutions will be necessarily limited by factors like complexity, the time needed to gather and analyze evidence, and the basic capacity limitations in any court, like any prosecuting body. In its prosecution functions, freezing and forfeiting illicitly acquired assets will be restricted to the criminal cases on the docket, and the restitutive function of the court will therefore be limited. So how to deal with the tens of billions otherwise taken that are not touched through the criminal function of the court? Our proposal is to establish a court with two chambers, one for prosecuting crime and the other a civil chamber to adjudicate disputes with respect to the recovery of assets. It would oversee and facilitate through a civil procedure the forfeiture, return, or repurposing of funds and physical assets acquired through corruption. Now, this is a proposal that's of particular interest to the Global South. Typically, not exclusively, but typically, money is stolen from the treasury of developing countries and put on deposit in Singapore, Switzerland, Canada, UK, or New York. When the developing country has a change in government and wants the money back, it must engage in a protracted and complex and uncertain process to try to retrieve it. There's a famous case involving a crook who ran Nigeria called Sani Abacha, who looted the treasury of billions of dollars. He's now been out of office for more than a decade, but there is still a dispute between Nigeria and Switzerland trying to recover that money so the government of Nigeria can use it to pave roads, build schools and hospitals, and provide social services to the population. It shouldn't be that way. There ought to be a forum in which the merits of Nigeria's claim for the recovery of those assets can be adjudicated upon in an impartial and independent way so as to produce a just result and get the money back in the hands of the people victimized by the kleptocrat. That's what the civil chamber of the International Anti-Corruption Court would achieve. Mechanisms and processes that go beyond criminal prosecution to focus on the proceeds as well as the perpetrators, on civil remedies as well as criminal prosecution, and on restitution as well as punishment. And in doing so, we believe the civil chamber of the IACC can meet a crucial need and respond to the calls emerging from many quarters for an institutional mechanism to assist states and all interested parties with asset recovery. It's worth noting that the civil chamber would operate on the civil standard of proof, the lower standard of proof, not the criminal standard of beyond a reasonable doubt, balance of probabilities, and so would be able to adjudicate on that basis. Now, let me turn to the question whether it's possible to create such a court in today's crazy, badly organized world. Well, first of all, I'll tell you what we've been doing. An international team has been working for the last 3 years under the leadership of Justice Goldstone to draft a treaty that would create the court, like the Rome Statute, which is actually a treaty that was negotiated in the 90s for a court that began operating in 2002. The draft treaty will be available for circulation later this year. The Goldstone Group, on which I serve, has been supported by 90 scholars and practitioners in international law who provide timely responses to questions we confront and provide opinions on the alignment of our treaty proposals with international law. As to strategy, we propose to use what some refer to as the Canadian model of international law reform, and we hope that Canada will be a leader in the effort to persuade others to adopt the treaty. The Canadian model has made significant contributions in the past, particularly in relation to the creation of the International Criminal Court, but also the Landmines Treaty to which I referred, and the unanimous adoption by UN member states of the responsibility to protect in 2005. As to levels of support for the IACC, in my own country, in Canada, both of the major political parties support the notion. They've put it in their electoral platform. Increasingly, the Canadian private sector is supportive. Businesses in Canada see this as a way to level the playing field when they bid on contracts abroad. If they're looking for a contract to build a railway system or a building in a country across the sea, they're sometimes bidding against others who don't play by the same rules. Canadian businesses, when they're active abroad, are bound by Canadian law that prohibit corrupt practices. But our companies are competing against others located elsewhere who aren't bound by the same rules. But if there was an international anti-corruption court that was able to investigate and prosecute wrongdoing wherever committed and by whoever, the playing field will be leveled and we'll be able to compete with others by the same rules. So there's an attraction to this for the private sector throughout the world. As to other countries, the United Kingdom's Foreign Secretary, David Lammy, has committed his government's support. The European Parliament has passed a resolution supporting the creation of the court, and there's more support in Africa than in any other continent. And that's good because it's crucial that this not be seen as a northern plot, as a project just on the part of the developing countries for their own benefit. Indeed, it's anything but. And so we're encouraged by the level of support in Africa. And as I mentioned, some of the countries on that continent are particularly attracted by the idea of having a settled, fair, open process by which they can seek the recovery of looted assets when they want their money back. So there's a core group that is growing. The declaration in support of the court has been signed by 350 global figures, former heads of government and senior ministers. And that list includes 30 Nobel laureates. There are over 100 civil society organizations that have signed the declaration and support the creation of the court. And let me pause here for a moment to talk about the importance of global public opinion in any such venture. Wherever we went in the course of our work, whatever continent we were on, we found among members of the public anger and a seething resentment about the fact that they and their own communities have been victimized by crooks who get into office and exploit their position for their own personal gain. The people who suffer are the citizens of those countries who do not have the services, who do not have the infrastructure, who do not have the quality of life that they otherwise would have. And that's where we'll have the strongest support for this initiative. You know, I think we have to look particularly to youth as well. The next generation who see what's going on and say it's not satisfactory. They will not stand for it. They want to see change. And the creation of such a court would provide them with a means to achieve it. Give you a couple of examples. In Serbia, some months ago, a canopy over a railway station collapsed, killed 24 people. Well, an investigation quickly revealed that the construction of that canopy was faulty because the deal was corrupt. The minister in the government gave the contract to a friend for a kickback. The work was shoddy, it wasn't inspected, and a tragedy occurred. The students in Serbia began to protest. They were so deeply offended and angry, they went into the streets. They persisted in their protest. They occupied buildings. They made such noise that the prime minister eventually had to resign. That's an example of the kind of energy we can get behind this proposal. Moldova is another example where the government was overturned and replaced because the public, and especially young people, said they were no longer prepared to stand for the kind of theft they saw with their own eyes. So hope must rest with the next generation, the students and the youth who see what's going on, who are looking for a solution, and who we hope to convince to support this proposal as a meaningful way to respond. Canada will continue to be an active advocate for the court. We have membership in almost all international groups, whether it's the Commonwealth, La Francophonie, the G7, the G20, APEC, OSCE, NATO. That provides us with many opportunities for our advocacy. So I conclude by suggesting that the time has come for an effective response to this global scourge. That we need accountability for corruption through the enforcement of existing laws. And we need access by victimized countries to a fair and impartial way to adjudicate their claims for the return of the assets. And I'd be delighted to answer any other questions you may have about the proposal. Thank you.
I have a couple of microphones here. If you have a question, please raise it.
How would you ensure that the court doesn't become politicalized when dealing with nations that are already allied with you through previous treaties or just high-profile cases?
I think what would likely happen is that, as in the case of the International Criminal Court, cases would be accepted for investigation and prosecution if they're significant. In other words, it's in the ICC, it's not an isolated murder that takes the attention of the court. It is a significant war crime, crime against humanity, or a plausible allegation of genocide. So I think what the court would be interested in doing is looking at cases of significant corruption. And I know that's in the eye of the beholder. I don't think the treaty or the founding document would put a number on it. But I think it's going to be possible in exercising judgment to distinguish between trivial cases and those that merit the attention of such a tribunal.
Ambassador Rock, thank you again for your comments and congratulations on the foreign policy on ICE. I like that comment. My question is related to the review next year of the USMCA and your perspectives on that, as well as the corruption clause as part of that agreement that is focused potentially on Mexico and some of the cartel activity and other activities. Could you comment on that review and your perspectives of the enforcement of some of the corruption elements that are part of that agreement?
Well, as to the agreement itself, the agreement, as you know, replaced NAFTA. NAFTA, which was negotiated among 3 countries and adopted in 93, 94. That was torn up by the Trump administration when he was first in office. He negotiated the United States, Mexico, Canada agreement. And now he's tearing that up. So will you ask me what's in store? Who knows? We're dealing with someone for whom his own agreement is meaningless. So it's going to be very difficult for us to find a satisfactory basis for agreement again. In terms of the corruption provisions, there have been allegations of corruption arising from NAFTA and this agreement. I don't know that any have actually come before the courts for adjudication, but there's a section in the Global Affairs Ministry in Canada that's responsible for monitoring conduct and evaluating claims of corruption, and I expect that will continue.
How would this potentially impact foreign development projects undertaken by corrupt or authoritarian states?
I hope the impact will be that if money is given for development assistance, it'll be used for that purpose and not diverted for the personal benefit of those in power in that country. I mentioned the statistic from the Global Center, which estimated that 10 times the amount that's given that actually used is stolen. So we have a huge imbalance right now in the use of funds in development assistance. That's what we want to reverse. We want to make sure that the money that's given, whether it's for adapting for climate change or accelerating development within a country, is used for the purpose for which it's given. You know, one of the downsides of corruption is that it discourages donors. Why should we give when that percentage of the money is going to be illicitly taken? So restoring the confidence of donors, demonstrating that there are consequences for stealing the money, honing our ability to trace and track, I think that will have a huge impact internationally.
We have a question, excuse me, from the chat. So one of our online participants has said that you're kind to characterize the U.S. position as traditionally allergic to international justice organizations. Ms. Wolf asked that the ICC's earliest prosecutions were in the Global South. Would you anticipate a similar path to the IACC as perhaps an easier path to building credibility?
Well, I think I expect the court will take its cases as they find them. Don't forget that its jurisdiction will be complementary. In other words, the court won't investigate or prosecute if the state in which the corruption allegedly occurred is prepared to do it for itself. So if there are allegations of corruption in Canada, I would expect the Canadian authorities would investigate and prosecute. There wouldn't be need for an IACC. But if the money came from Venezuela and is on deposit in Singapore, and Singapore is a state party, then I expect that the court would exercise jurisdiction and proceed. So it's hard to predict, but in view of the fact that it operates on the principle of complementarity, it's reasonable to assume that the corruption that it investigates and prosecutes will likely have occurred in a country with an active government. In other words, the courts and the police are under the control of a thief. So prosecution is not likely to happen.
In the United States, we have a president who is, in my opinion, quite corrupt. involving other countries, that corruption. But we have a Supreme Court, now a Department of Justice, and cabinet position. If our courts won't and our Congress will not have the courage to stand up against it, how can the people of this country something? Is it something where there could almost be a class action suit by our citizens so that has to be investigated? And is that something that the IACC would have the stomach for? He's obviously somebody who's going to destroy anybody who goes against him.
Well, I'm reluctant to comment on domestic affairs as a guest in your country, but I would say that we've always regarded the United States, even before the current administration's election, as an unlikely participant in court, because the tendency of the policy in the United States is not to become a member of an international tribunal like that. And it's even less likely now with the current administration. As to remedies for the American people, I think the most ready answer is the ballot box, whether it's in the midterms or the next presidential election. And the American public will make up its own mind who should be elected and what the results of the election should be. I don't see a role for the International Anti-Corruption Court in that context. I can't imagine that it would become involved in the domestic affairs of the United States in that way. I think it's up to Americans to make their own decisions.
Do you expect the International Corruption Court to take up something that we're facing today, and that is Russian assets in foreign countries as a result of the Russian-Ukraine conflict?
I would expect, first of all, we are dealing with those. The government of Canada has adopted legislation authorizing our government to confiscate and forfeit Russian state assets and privately owned assets. That's pioneering legislation. It doesn't exist anywhere else in the world. And we're in the process now of considering the confiscation of some $16 billion in Russian state assets in Canada. It's already frozen and giving it to Ukraine. We've frozen it and we said we won't unfreeze it unless there's an agreement to pay reparations for the damage done by Russia in Ukraine. In terms of the oligarchs' assets around the world, certainly the IACC will look very rapidly and enthusiastic at corrupt Russian funds deposited in states that become parties to the IACC treaty, Switzerland, for example, Canada, Singapore, others. If there's tainted money, looted assets in those jurisdictions, then prosecutions can be initiated, investigations and prosecutions if justified. So absolutely yes. I think the oligarchs' money is a good example of the kind of corruption we're trying to root out.
I have a question. I was very heartened to hear that there is already international support for this idea. Would you mind speaking to how much support you have, how much discussion you have with countries in Middle East, India, China, Japan, basically, since obviously they're major investors as well in the world?
We've commenced discussions with a number of those countries. Many of them want to see the treaty before they go any further, and that's why we put a premium on the preparation of the document. Over the last 3 years, we've gone from the general to the more specific in drafting the treaty. Most of it's been done remotely on Zoom. That's difficult to make productive. So there's an institute in Hamburg, Germany, which has made its facilities available to us for 3 weeks at a time, each of the last 3 years. And we've gone to Hamburg and we spent intensive days on the drafting process, discussing the issues, finding the language, and putting the words on paper. We hope to have that treaty in a form that can be shared with others later this year. This is now February, as I recall. Hopefully by summer, we'll have a draft treaty we can distribute. I think that's when we're going to go in a serious way to other governments, the Middle East, you mentioned India, China, to test their reaction and their interest in the proposal. And we'll do that both directly and indirectly, of course, in the coming months.
We have time for one more question.
Hi, thank you. So I understand that the ICC would address, or it's crooks, excuse me, that get into office, but I'm curious what role it would play with criminals in general, specifically organized crime or groups that are not necessarily associated with specific sovereigns.
Well, if organized crime engaged in corruption, such as the payment of bribes, then they would be subject to the court's jurisdiction, all other things being equal. So the court would have jurisdiction to go after heads of government, other senior officials, enablers like the lawyers and the accountants and the financial advisors, but also private actors who engaged in corrupt conduct. If a Canadian company, for example, well, we enforce our own domestic laws, but if a company from Germany was doing business in the Middle East and paid a bribe to get a contract, then if Germany wasn't prepared to prosecute that company, the International Anti-Corruption Court could. As to organized crime, if they engaged in corrupt conduct, they too, in proper circumstances, might be subject of investigation and prosecution.
Ambassador Rock, thank you so much for sharing your vision.